Welcome to the deep dive. Today, we're tackling a really important piece of legislation, the Intimidation Act 72 of 1982, in its consolidated form. Yeah, this act is kind of interesting because it needs to be super clear for, the general public about what's illegal when it comes to threats, but it also needs that legal depth for, say, law students or lawyers.
Exactly.
So our goal today is pretty straightforward. Unpack what this act is trying to do, look at its key sections, and figure out its real-world impact, especially how it shifted focus over time.
Okay, so just to set the scene a bit, the act got its final approval, the assent, on May 22nd, 1982. And it kicked in just a few days later, June 2nd. Its official purpose is pretty direct: to prohibit certain forms of intimidation and to provide for matters connected therewith. Short and sweet.
Right, but 1982 sounds like ages ago. Is this thing still relevant?
Oh, absolutely. It's kept up to date. I mean, the version we're looking at includes changes made as recently as January 4th, 2023. That came from Act 23 of 2022. So, yeah, it's definitely a living law.
Okay, so it's actively maintained.
And thinking historically, its structure was significant right from the start. If you connect it to the bigger legal picture, this act specifically got rid of sections 10 to 15 of an older law, the Riotous Assemblies Act of 1956.
Right, the Riotous Assemblies Act. So taking those bits out and giving them their own act. What was the point of that? Why separate intimidations specifically?
Well, it looks like a strategic move. That older act was quite broad, covered illegal gatherings, public disturbances, that kind of thing. By creating a standalone Intimidation Act, the lawmakers basically carved out the specific crime of forcing someone through fear, gave it its own dedicated framework, separate from just controlling riots.
Okay, so it put a spotlight on coercion itself.
Exactly. It gave intimidation its own statutory home, which we can now dig into, starting with the original offense in Section 1. Okay, let's unpack this.
All right, Section 1. This is kind of the foundation, right? It seems to focus on very specific, targeted intimidation aimed at particular people or maybe specific groups. When we break down what actually makes something an offense under this section, we need that balance, like you said, clear language but legally precise. So what's the core mental element, the mens rea, needed for Section 1A?
Okay, the intent here is very specific. First, the action has to be done without a lawful reason. That's key. And second, it must be done with the intent to compel or induce someone or a specific group to basically change what they're doing. That change has to involve either forcing them to do something or to stop doing something, or maybe to take up a certain viewpoint or abandon one.
So it's not just about making someone scared in general. The point is to actually force a specific result. Like you want them to drop a lawsuit or quit their job or maybe change their vote. It's about compulsion, aimed at a concrete change in behavior.
Precisely. And the action itself, the actus reus, is directly tied to violence or the threat of it. The person accused must either, number one, assault, injure, or cause damage to the victim, or number two, threaten to kill, assault, injure, or cause damage. If you link that action or threat with the specific intent to compel we just talked about, then boom, you've got the offense.
But isn't that quite a high bar? Proving that specific intent to compel someone to do or not do something specific seems like it might be tough outside obvious situations, maybe like workplace bullying or domestic threats where the motive is clearer.
It absolutely can be. Yeah, the prosecution really has to establish that specific intent, and that's often the tricky part. But the potential penalty shows how seriously the law takes it. For this kind of targeted intimidation under Section 1, the penalty is quite stiff. A fine up to $40,000 or prison for up to 10 years, or potentially both.
Okay, so that's a significant penalty for those direct personal threats aimed at compulsion. But things change. Threats evolve. The country started facing, bigger issues than just individual disputes, right? More like large-scale fear tactics. How did the law adapt to that?
Yes. That brings us to a really major addition. Section 1A. This was brought in much later by Act 126 of 1992. And this section addresses a whole different level of threat. We're talking about intimidation aimed at the general public, or maybe a large segment of the population, or everyone living in a particular area.
Right, so this isn't about making one person sign a contract anymore. This sounds more like trying to paralyze a whole community or, society itself. What's the intent required under this Section 1A1? How does it differ?
The focus shifts completely. The mens rea here isn't about compelling a specific action. Instead, the intent is to put in fear, or to demoralize, or to induce the general public, or that section of it, to do something or stop doing something. Think about the difference. Compulsion under Section 1 might be about stopping a strike, a very specific thing. Demoralization under 1A is broader. It's about creating widespread fear, making people afraid to go out, maybe disrupting daily life or undermining public confidence. It's basically the law recognizing and tackling terrorism and public destabilization.
Wow, okay. The jump in seriousness is obvious just from that description. And Section 1A1 lists 4 ways someone can commit this public intimidation. Looking at these points, A through D, it goes way beyond just committing violence itself.
It really does. So Category A is the most direct,
Yeah.
actually committing, threatening, or attempting an act of violence. Straightforward enough. But the law gets smarter, especially when dealing with, say, organized groups or terror cells. That's where the other categories come in.
Like Category B. It mentions performing any act aimed at causing, promoting, or contributing towards that violence or threat. Why was that needed?
Well, think about preparatory steps. If you're gathering bomb-making materials or maybe mapping out a target or even spreading propaganda specifically to encourage violence later under 1A, 1B, you're already committing the offense, even before anything blows up. It targets the planning, the buildup.
Okay, so it nips it in the bud, potentially.
Right. And the same idea applies to working with others. Categories C and D really focus on the group aspect.
Let C is about conspiring with someone else to commit the violence or help out. And D seems to catch everyone else involved.
Exactly. Category D covers inciting, instigating, commanding, aiding, advising, encouraging, or procuring others to commit the act or make the threat. It's a really wide net. Brings in the leaders, the planners, the helpers, the foot soldiers. Everyone involved can be held accountable.
And given this is about threatening society itself, the penalty must be way higher than for Section 1, right?
Oh, massively higher. It really underscores how the priorities shifted. Under Section 1A, the penalty is a fine, and the court decides the amount. There's no upper limit stated or imprisonment for up to, get this, 25 years.
Oh.
Or it could be both.
25 years. Okay, that sends a very clear message about the perceived gravity of trying to destabilize the public.
Definitely. It's a huge jump from the 10 years under Section 1.
But proving that kind of widespread intent, the intent to demoralize a whole population, that sounds incredibly difficult in court. Which I guess leads us to the next part, Section 3, which talks about definitions and, crucially, these legal tools that help prosecutors make their case. This part might be particularly interesting for law students listening.
Yeah, absolutely. But before we jump into the presumptions, we need to be clear on what violence actually means within Section 1A. The Act defines it in subsection 4, and it's defined pretty broadly. It includes inflicting bodily harm, killing someone, endangering anyone's safety, or damaging, destroying, or endangering property, so it covers a lot of ground.
Okay, a wide definition of violence. Now let's talk about these tools, these presumptions. Section 1A2 sets up a presumption of intent. How does that work? How does the result of an act help prove the intent behind it?
Okay, so it works like this. If the prosecution can prove 2 things, first, that the accused actually committed the act in question, and second, that this act either resulted in or was likely to have resulted in achieving those illegal goals from Section 1A1, putting the public in fear or demoralizing them. If they prove those 2 things, then the law presumes the accused had the necessary intent. The burden then shifts. It's up to the defense to prove that, actually, no, they didn't have that intent.
Wow, okay. That's a powerful shortcut for the prosecution. If your actions were likely to cause public fear, the law assumes you intended to cause that fear, unless you can show otherwise.
Exactly. And it gets even more specific with the presumption linked to certain types of weapons. That's in Section 1A3. Just unlawfully having specific military-style weapons can trigger this presumption of intent to commit public intimidation.
That's fascinating. And you mentioned the specific types of weapons. It's not just any illegal gun, is it? What kind of items are we talking about? Can you run through that list?
Sure. The Act lists them very clearly. An automatic or semi-automatic rifle, a machine gun, a submachine gun, a machine pistol.
Hold on just a sec there. Stopping you for a moment. Automatic rifles, machine guns, these are weapons designed for maximum casualties really quickly. Why single out this specific class?
Well, the thinking seems to be connecting the tool to the likely purpose. Possessing these kinds of weapons, unlike maybe a simple handgun or a hunting rifle, strongly points towards an intention that goes beyond personal defense or ordinary crime. These are instruments inherently linked to large-scale violence, the kind that destabilizes communities, which is precisely what Section 1A is trying to prevent.
Got it. So the weapon itself suggests the scale of the intended harm. Makes sense. Okay, please continue with the list.
Certainly. So after machine pistols, it includes a rocket launcher, a recoilless gun or mortar, or any ammunition specifically for those weapons or any component part of them. And it also includes any grenade, mine, bomb, or explosive.
Okay, so if someone's caught unlawfully holding, say, a mortar or a crate of grenades, What does the law automatically assume?
It assumes, again, unless the person can prove otherwise, that they possess that weaponry with the intention of committing one of those illegal public intimidation acts listed back in Section 1A1.
The prosecution doesn't necessarily have to show a detailed plan or a specific target date. They just need to prove the unlawful possession of those military-grade items, and the law presumes the intent was to create public fear or demoralization.
Right. So wrapping this up for you, the listener, what does this all mean? If we boil it down, the key difference between the two main sections is about the target and the goal. Section 1 deals with intimidating specific people or groups to force them to do or not do something. The penalty reflects that personal scale up to 10 years. Yeah, whereas Section 1A is all about the bigger picture. Acts aimed at creating widespread fear, demoralizing a whole community or the public, essentially. Acts of terrorism or public destabilization. And that massive potential penalty, up to 25 years, shows how seriously the state views threats to the entire social fabric. And those legal tools we discussed, especially the presumptions based on likely outcomes or possessing heavy weaponry, they feel like a clear strategy to make it more feasible to prosecute these really serious but often hard-to-prove threats against public order.
And looking at the bigger picture again, the whole story of this act, especially adding Section 1A back in '92 and the ongoing updates, it really shows how law has to adapt to changing threats in society. It marks a clear shift from dealing with, say, picket line intimidation to confronting large-scale organized violence designed to terrorize. The state basically expanded its toolkit to go after those using mass fear as a weapon.
A necessary evolution, you could argue.
Absolutely.
Hmm.
Which leads to a final thought, maybe something for you to chew on. We know proving intent is one of the hardest things in criminal law. So how effective do you think these legal shortcuts, these presumptions in Section 1A, like assuming intent if someone has a rocket launcher, actually are? Do they strike the right balance between ensuring accountability for truly terrifying acts and, the fundamental principles of justice where the state has to prove every element? It's definitely an interesting tension.